Hello Real Estate, George here, and today let's talk about buying lots with tax declaration only. Is it possible to buy a lot with tax dec only? Is this legal? What are the risks and benefits? Watch this video and learn. But before we dive into it, if this is your first time in this channel, please don't forget to hit on the subscribe button and the notification bell so you will be informed for new videos coming out from this channel. So, here we go. A tax declaration is not a proof of ownership. At best, it's only a proof of possession. Here is the problem. Anyone can pay a real property tax or AMILYAR and be issued a tax declaration by the city assessor's office. Even people squatting on your titled land can pay. The government does not care who pays it as long as it is paid. That is why it is not a conclusive proof of ownership, unlike the land title under the Torrens system, which is issued by the Register of Deeds. So what is the difference between a tax declaration and a certificate of title? Can a tax declaration serve as a title? A tax declaration is a document that a land is declared in the assessor's office of the town where it can be found for the payment of real property tax or AMILYAR. But it cannot be called a title under the Torrens title system. A Torrens title system is a system where land ownership occurs when the document that transfers ownership of the property is filed at the Register of Deeds, naming and declaring the owner of the real property described therein free from all liens and encumbrances, except such as may be expressly noted thereon or otherwise reserved by the law. In short, the Torrens system is established to provide certainty of title to land, while tax declarations and receipts are not conclusive evidence of ownership and do not prove title to the land. Nevertheless, when coupled with actual possession, they constitute evidence of great weight and can be the basis of claim of ownership through prescription. I know there are a lot of buyers that are interested in buying lands that only has tax declarations to show for, primarily because they are cheaper. But to avoid complication or worse, losing your hard-earned money, it is best to have it titled first. Now, there are two methods of land registration: judicial proceeding and administrative proceeding. The judicial proceeding is where you need to file a petition for court registration. It may either be voluntary, where it is instituted by the applicant under the provisions of Act 496 or PD 1529, or the Property Registration Decree, where the following may register under this law: those who have by themselves or predecessors in interest have been in open, continuous, exclusive, and notorious possession and occupation of alienable and disposable lands of the public domain under bona fide claim of ownership since June 12, 1945 or earlier. Those who have acquired ownership of private lands by prescription under provisions of existing laws. Those who have acquired ownership of private lands or abandoned river bends by right of accession or acquired under existing laws. And those who have acquired ownership of land in any other manner provided for by law or compulsory at the instance of the state under provision of Act 2259 or the Cadastral Act, or involuntary, where the state initiates the land registration. The second method of land registration is through administrative proceeding. This is a procedure where there is no need to go through the court. What you need to do is file an application for homestead patent to the DENR, and the registration of this patent will be the basis for issuing original certificate of title pursuant to Commonwealth Act 141 or the Public Land Act. For more details on who are qualified and how to apply for a homestead patent, I'll be putting the link in the description and the comment section below. But what if you are willing to take the risk and not wait for the land to be titled and just accept the tax declaration as proof of ownership? Most of the time, it's not a good idea, but for the purposes of discussion, here are the 7 steps you can do. First is choose a licensed real estate broker or real estate salesperson, and if necessary, hire a lawyer, especially if you're dealing with big amount of money. A licensed real estate or licensed salesperson to assure you that you are supported with a knowledgeable and professional person, and a lawyer to guide you in every step of the way as prescribed by the law. Next is do your due diligence. never purchased an untitled property without inspecting it first. Compare it with the photos and documents issued by the seller, and you might also want to ask the neighborhood who have been in the area for quite some time to inquire about the history of the property, and let your real estate agent do the work to make some background checks as well. Then proceed with the municipal tax assessor. Ask for a copy of the tax declaration directly from them and compare it against the one presented by the seller. Fourth is secure a copy of the map, if there are any, from the Land Management Bureau under DNR, so you would know exactly what the boundaries are. This will validate your ocular inspection. Next is check the registry of deeds to see if there is really no title. If there is an existing title, then at least you have done your due diligence and avoid being scammed. But let's say that there is really no title. You then inspect the chain of ownership by tracing the property back to the person named in the property tax map. The most important thing is to see that they are the legal heirs of the named owner, being his or her son or daughter. Hiring a lawyer to do this can also help you a lot, because even if there is just a single heir that refuses to sell the property, this will be a serious problem. And the last one is surveying the property by a licensed surveyor. You must make sure that the property's metes and bounds are properly described in the deed of sale. This is called a relocation survey. Now, there is a big chance that there will be changes in the metes and bounds. This could especially be true if the last survey on this property took place ages ago, where technology isn't as advanced. In summary, you can buy a land with only a tax declaration to show for, but the risks are high. You might be dealing with someone who is not legally entitled to the property, or the same property might be sold to two or more different persons. But if you're up to the challenge of a possible lengthy litigation, then you can go ahead. But please take note that the tax deck properties are common only to far-flung islands and provinces like Boracay or Bantayan. If someone offers to sell you an entitled property in the city like Manila or Cebu, then you might need to review the steps mentioned to validate the legitimacy of the property. So there you have it, and I hope you learned something new. Once again, this is George Ryan Sarmago, Unit Manager for Filipino Homes and a PRC registered and DHSUD accredited salesperson. Thank you for watching. Stay safe, stay at home, and peace.